Good evening, everybody. Thank you very much. So my name's Louise Gullifer. For those of you who don't know me, I'm chair of the law faculty here at Cambridge, and it's my great pleasure to welcome you here for one of our most important events of the year. It's an important annual lecture that's given at the faculty. The Sir David Williams Lecture has been an annual event since 2001, and for those of you who don't know, probably students, it was delivered in honour of the late Sir David Williams, who was one of the most eminent public lawyers of his generation, hence the public law focus of the lectures. Now, again, many of you will have remember Sir David, or at least know who he is. But for those of you who don't, you might be interested to know a little bit about him. And for students who are here and observant, you may have noticed that we're in a building called the David Williams Building, which indicates how important and eminent Sir David was to this faculty and to Cambridge. Now, I did a bit of research. I'm not sure it's terribly rigorous, but as far as I can tell, he was the only Cambridge law professor ever to become Vice-Chancellor of the university, certainly in modern times, and he was certainly the only Cambridge law professor to become a full-time Vice-Chancellor of the university. Before that, he studied at the university. He was at Emmanuel College. He spent a few years in Oxford as a Fellow of Keble, and then he came back to Cambridge as President of Wolfson College and Rouse Professor of English Law. And that's why the building was named after him, because of his great distinction and service both to this faculty and to Cambridge. Now, we're very honoured today to welcome some of his family, including his widow, Lady Sally Williams. It's lovely to have you with us, and other members of his family who, well, in my experience anyway, come to this lecture regularly, and we're delighted to see you. Now, the overarching theme, as I said, is public law. And actually, we have another distinguished professor from the Cambridge Law Faculty to give the lecture this year, Professor Emeritus Trevor Allan, who I didn't coincide with for very long, but it's lovely to have you back again. And he's going to be introduced, and the lecture is going to be chaired by Kirsty Hughes. So I'll hand over to her now. Thank you very much indeed.
Well, as Director of the Centre for Public Law, it's a great pleasure and a privilege to introduce our speaker this evening. As Louise has indicated, this lecture series is named in honour of Sir David Williams, and I echo Louise's gratitude to the Williams family for being here this evening and for all their support with this event. Sir David Williams was a highly distinguished legal scholar, producing landmark works on official secrets, public order, civil liberties, and public law. He was, as Louise indicated, president of Wolfson College and vice-chancellor of this university. And he has an enduring legacy, not only for his work, but also the values he fostered, in celebration of which this lecture series was generously founded by John Nolan and Michael Ross. The first lecture was given in 2001 by Sandra Day O'Connor, the first female Associate Justice of the US Supreme Court. And since then, the Sir David Williams Lecture has been given by a rich array of speakers, including eminent academics, practitioners, and senior members of the judiciary. Our speaker this evening is, of course, our very own Professor Trevor Allan, King's Counsel Fellow of the British Academy. I have had the honour of working with Trevor for many years, and he is a colleague of the highest integrity. Trevor has been dedicated to common law constitutional theory for over 40 years. He shaped the field in a manner which is unparalleled, and his work is influential around the world. What I admire most about Trevor is his impressive ability to articulate and defend his constitutional vision, while also engaging genuinely with opposing views. Over the years, I've seen Trevor debate with students, faculty members, visiting professors. Not only does he always have something astute to contribute, but he also listens. He thus exemplifies academic excellence, curiosity, respect, and dignity. This is evident throughout his work. In his 1994 book, Law, Liberty and Justice, Trevor rejected a purely formal concept of the rule of law, arguing that public law should more fully and openly reflect the principles of liberty and justice, which constitute the underlying point and substance of the rule of law. He thus argued that the sovereignty of Parliament is necessarily limited by residual principles of liberal constitutionalism. Any other view would contradict the rule of law. Trevor has consistently argued since then in Law, Liberty and Justice, as well as his 2001 book, Constitutional Justice, and his 2013 book, The Sovereignty of Law, that if the rule of law is a constitutional principle of real importance, capable of moderating the influence of majoritarian politics, especially in times of emergency or stress, it must be more than merely formal. It must embrace a range of familiar liberal rights and freedoms intended to guarantee each person's autonomy or independence. Trevor's work on the rule of law is enduring, but it is also timely. Earlier this month, the House of Lords Select Committee on the Constitution issued a report observing that, despite a long history in the UK, the rule of law's endurance and vitality is not guaranteed. They concluded that we should not be complacent about the rule of law. It is of vital importance to our society and our everyday lives. We should protect and nurture it. Well, Trevor has certainly not been complacent. It is, therefore, with great pleasure that I invite Trevor to give the 2025 Sir David Williams Lecture on the subject, Neither Parliamentary Sovereignty nor Judicial Supremacy, the Rule of Law as the Rule of Common Right and Reason. Thank you.
Thanks, Kirsty, for those very kind words. It's almost exactly 40 years, as it happens, since I first arrived in Cambridge as a young academic. And I remember sitting in the old Squire Library, now part of Keys, shortly before the start of term, feeling really quite apprehensive, reflecting I knew almost no one here. And then in burst David Williams, carrying a large pile of books, who very kindly stopped and introduced himself. On the strength of that brief introduction, I dared to send him a draft of the article I was working on, seeking his comments. David very quickly replied that the article was okay, but we should go out to lunch at Grantchester to discuss it properly, which we duly did. And I returned home with an armful of relevant materials from David's own collection that he thought might be useful to me in finishing the piece. It was that characteristic kindness, after that characteristic kindness, I really began to feel at home. With senior colleagues like David Williams, I thought, Cambridge might just work out all right. I want to argue that our public law is distorted by a false antithesis. We are, it's widely thought, confronted by a choice between parliamentary sovereignty on one side and judicial supremacy on the other. Either there are no legal or constitutional limits to legislative power, however much a provision may appear to threaten basic rights or values, or else we must submit to government by the judiciary, which is inherently undemocratic. There appears to be no way out. Somebody, in the usual phrase, must have the last word. But I believe we can find a more satisfactory path between these unappealing poles. enabling us to acknowledge Parliament's legislative supremacy without abandoning the judicial role in defence of the rule of law. And we can't simply abandon the rule of law in any circumstances, in my view. It traces out the line, I think, between law on the one side and arbitrary, illegitimate power on the other. Of course, any attempt to find a more nuanced path between opposing positions risks antagonizing both sides of the debate. An old friend recently told me she'd adopted a rather similar strategy in discussion when a colleague of hers, no doubt reaching for the worst insult he could think of, rounded on her, "For heaven's sake," there I paraphrase, "you sound just like Trevor Allan." Well, I'm sorry, but that's a problem I can't very well avoid. The familiar antithesis was paraded by Lord Sumption, notably in Privacy International. He said, "In the absence of a written constitution capable of serving as a higher source of law, the status of parliamentary legislation as the ultimate source of law is the foundation of democracy in the United Kingdom. The alternative would be to treat the courts as being entitled on their own initiative to create a higher source of law than statute, namely their own decisions." But talk of creating a higher source of law suggests to me a dubious voluntarism. It supposes that law is only the product of an act of will, whether Parliament's command or judicial diktat. Could the courts not instead simply recognise a higher source of law, embracing certain general principles of legality and good governance that have their basis not in anyone's say-so, but in political morality, the morality we invoke whenever we condemn oppressive regimes abroad or appeal at home to ideas of justice or fairness or human dignity or human rights? I want to challenge the standard model in which a sovereign parliament issues binding commands. The words of the statute express the legislator's instructions, it's supposed, and any failure to follow them amounts to unjustified disobedience. If the scope for judicial discretion on this view, it's only at the margins, where the language is ambiguous or contradictory, or if taken too literally, might jeopardize the statutory purposes. Yes, it may well be the duty of the courts to uphold the rule of law, but only as far as the statute allows. The courts on this model are merely the servants of Parliament, rather than guarantors of legal and constitutional principle. That language of commands, instructions, and obedience assumes that law is simply an expression of will, ultimately the will of the legislators. When we acknowledge constitutional rights on that view, we invoke them only as tentative but defeasible assumptions vulnerable to curtailment by any sufficiently strident contrary stipulation. Hence the principle of legality, as most famously articulated in Lord Hoffman's judgment in Sims. The only limits on parliamentary sovereignty, he maintained, were political rather than legal. The principle of legality meant merely that Parliament must squarely confront what it's doing and accept the political cost. Always supposing, I want to add, that there would be any political cost. He said, fundamental rights cannot be overridden by general or ambiguous words. This is because there is too great a risk that the full implications of their unqualified meaning may have passed unnoticed in the democratic process. But it's surely inevitable that the full implications will have passed unnoticed. they will become evident only as novel cases arise to be considered. Ambiguity is a product of unfolding events. It lies in our natural uncertainty about how far the context ought to make a difference. The interpreter, then, has, in effect, to complete the process of enactment, deciding in the light of all relevant considerations whether a statutory provision applies on the facts, and if so, what its legal effect may be. The intelligent and conscientious application of statutes, I'm arguing, is a matter of reasoned judgment, carefully attentive to the specific context. It's not truly about obeying orders or instructions. It doesn't involve capitulation to anyone's will. Statutory interpretation, it follows, is inherently sensitive to all the basic principles of the legal order, which steer us towards the correct answer in the particular case. Those general principles are always part of the relevant context. I'm only reminding you of what our common law forebears have always understood, even if that understanding seems now much less secure. Chief Justice Coke famously said in Bonham's case in 1609 that an act of Parliament made against common right and reason would be void at common law. He did not mean, I think, that such an act would simply be struck down by the courts as a nullity, but rather that it would be void in the sense that it had no application to the case in point, and perhaps no obvious application to any other case very likely to materialize. This is simply because no reasonable person would think it ought to apply in the circumstances currently in view. And according to Coke, that includes the legislator. He says, some statutes are made against law and right, which those who made them perceiving would not put them in execution. The question of obedience, then, is neither here nor there. To apply the statute involves trying to make sense of it as a contribution to justice in the specific context, the context of the particular case in point. How, if at all, does the Act alter the previous law as a means of correcting what members of Parliament evidently considered unjust or injurious to the common good? In trying to interpret the statute in that way, we take a degree of responsibility for the outcome, construing the Act in a way that reflects well rather than badly on its authors. Even Hobbes, for whom law was indeed the command of the sovereign, conceded as much, observing that the intention of the legislator is always supposed to be equity, for it were great contumely for a judge to think otherwise of the sovereign. If, Hobbes continues, the word of the law do not fully authorize a reasonable sentence, the judge should supply it with the law of nature, advice which surely finds an echo in Justice Byles' famous dictum in Cooper and Wadsworth Board of Works in 1863. So strong is the presumption that Parliament intends no departure from procedural fairness, or natural justice as it's so well named, that if necessary, quote, the justice of the common law will supply the omission of the legislature. A striking modern example of robust common law interpretivism is Evans, in which the Supreme Court declined to accept that a government minister could overrule the decision of a court, the upper tribunal, because he disagreed with it. The ministerial veto, so-called, was not to be taken too literally. I know I'm stirring up a hornet's nest here. The decision has been widely criticised, but nevertheless, I think the critics are mistaken. The issue was whether certain correspondence, the Black Spider memos penned by Prince Charles, then heir to the throne, should be disclosed under the Freedom of Information Act. Critics object that it was all a matter of balancing public interests. The public interest in disclosure against any public interest in confidentiality, which a minister can arguably do better than a judge. But they miss the critical point, I think, that that balance of interests supplied the legal standard for judgment. And it was a standard that required an assessment of constitutional principle. It involved freedom of speech, specifically freedom to publish information relevant to the role of the monarchy and the nature of our democracy. The tribunal was the only impartial arbiter here, and its elaborately detailed reasoning showed that the minister's view was wholly untenable. Charles's advocacy correspondence, as the tribunal described it, did not obtain protection under the so-called Education Convention, whereby the heir learns in confidence about the nature of British governance. There were no reasonable grounds for the view that the Act permitted non-disclosure, as Section 53 requires, even if the minister claimed the opposite. Note that the Supreme Court didn't strike out the provision in the Act that granted the minister a qualified veto. It held that such a veto could only be properly used in very unusual, perhaps rather unlikely circumstances, not including the present case. The court was right, in my view, to resist a simplistic literal reading. The judges were defending the rule of law against an arbitrary ministerial rejection of a cogent and compelling judicial decision. I'm rejecting the view that law is a species of empirical fact. This is the idea that statutes lay down certain rules which impose whatever duties or demands their language specifies. That view leads us, I think, into serious problems. We're faced with an apparently insoluble moral dilemma. Should we support a measure on democratic grounds? It's the product of a democratic process. Or should we reject it, or at least try to evade it, on grounds of justice? And there's no secure basis for seeking common ground. We disagree about political morality, taken in the abstract, and hence about the nature and scope of individual rights. We seem to confront a choice between unvarnished majoritarianism on one side and potential anarchy on the other. The way out of the impasse, I think, is to insist that law itself is always a reflection of political morality. The morality embedded in the principles and doctrines that express and shape our most fundamental commitments to liberal democracy and constitutional rights. Every legal judgment is an expression of those commitments, adapted to the circumstances in which it applies. The law is not to be equated with official decree, I'm insisting, but nor should we think it corresponds to an ideal of justice that we can discern quite independently of our legal and constitutional practice. The law is not simply a reflection of universal principles of right, impervious to the specific context. Coke was right to think that we must look to the common law and thereby to our own traditions for knowledge of the law's content. But practice and tradition are not matters of empirical fact. They are a source of moral knowledge and understanding. The law is best conceived, I think, as a more local or uniquely British instantiation of a grander ideal, the ideal of the rule of law. Coke's artificial reason is ultimately an interpretation of natural reason, but natural reason needs a more readily accessible avatar. What then is the rule of law? It shouldn't, I think, be conflated with what Lord Fuller famously called the inner morality of law. This was mainly limited to the various formal and procedural constraints that serve to make enacted rules fit for their purpose. Such rules are publicly ascertainable only if they are published, prospective, clear, non-contradictory, and so on. But though important, there's much more, I think, to the rule of law than that. The rule of law obtains when there are no unregulated pockets of arbitrary power, power wielded at the whim of an unaccountable power holder. Every coercive act by a public official must be capable of justification by recourse to settled rules and familiar principles. The rule of law thereby entails equality before the law, not merely in the pedantic sense that the rules should apply to everyone, whatever their content may be, but in the more important sense that they treat everyone with equal dignity, equally entitled to the benefit of the general principles of justice that the law, construed as a unified body of interrelated standards, assumes or proclaims. Common law adjudication, I think, consists in the working out case by case of the practical implications of that commitment to the rule of law. It generates and reaffirms our public conception of justice, the principles of justice that ultimately define our constitutional arrangements as a genuine legal order, a regime worthy of anyone's allegiance. Principles and precedent are interdependent. We invoke the principles to make sense of the precedents, and the precedents in turn show us what the principles mean in practice, giving abstract ideals a more concrete expression. We can draw an analogy, I think, with John Rawls's idea of reflective equilibrium, the idea that in ethical reasoning we try to bring our moral intuitions into harmony with general principles in a mutually supportive way. We do much the same in common law reasoning, but with examples taken from familiar precedent rather than shared moral intuitions. The principle of legality, then, can be straightforwardly understood as demanding adherence to the rule of law, allowing the exercise of power only insofar as it's justified. Constitutional rights must be given the weight or force appropriate to the specific context. If we think, as the House of Lords accepted in Sims, that investigative journalism can sometimes expose a miscarriage of justice, we should disallow overly restrictive prison rules that impede a journalist's efforts to explore the safety of a doubtful conviction. We should interpret the minister's powers under the Prison Act to make rules for the regulation of prisons accordingly, those powers being subject to compatibility with basic constitutional values. It's not a matter of divining certain legislators' intentions, even hypothetical intentions, or following implicit instructions. It's simply a matter of reasoned judgment, responsive to all the available evidence. Insofar as there are constraints on the exercise of basic rights in certain cases, we can embrace a principle of proportionality. Statutory limitations are justified only insofar as they're strictly necessary in all the circumstances. There's no arbitrary balancing of rights against interests here, or weighing of incommensurable interests. We merely acknowledge that a legitimate sentence imposes certain inevitable constraints on the exercise of a prisoner's rights, which are nevertheless preserved as far as practicable. Now, combining the principles of legality and proportionality in that way admittedly prompts the objection in certain quarters of inconsistency. While Lord Hoffman might require Parliament expressly to qualify basic rights if it sees fit, we could hardly expect it to foresee all the different circumstances in which statutory powers may need to be curtailed to accommodate common law rights. So how do we know whether Parliament would have approved of the various constraints imposed on the scope of a power in particular instances? But our response to the objection is plain. We reject its premise. It's not a matter of what the legislators intended or foresaw, or would have intended or foreseen. It's simply a matter of what, in context, justice requires. We cannot then concede that genuine rights can be simply overridden by clear or express language, let alone by necessary implication. That would be a denial of rights, a flagrant breach of the principles of justice that the rule of law affirms. Of course, we can properly argue over what in each context a right actually requires or prohibits, founding our arguments as much on familiar practice or settled tradition as first principles. But that's a matter of reason, sophisticated common law reason, not legislative fiat. In any case, the language is never sufficiently clear. The greater the threat to fundamental rights, the weaker the linguistic resources for plausible encroachment. Such resources eventually peter out entirely. A statute that purported to penalize a political opponent, for example, would have to name its victim. Its very clarity and specificity would undermine its status as a genuine law. A bill of attainder is an explicit repudiation of the rule of law. Do you recall the pristine clarity of the ouster clause in Annus Minich? The Foreign Compensation Act provided that no determination of the tribunal can be called into question in any court of law. The House of Lords held that the clause did not apply in the case of jurisdictional error. The tribunal could not be allowed to exceed the limits of its statutory authority. It's part of the standard view, I think, to treat that decision as an example of power play between the courts and Parliament. The courts were allegedly disobeying their clear instructions, even if we think that perhaps they were right to do so in all the circumstances. A sort of doublethink operates here. Absolute parliamentary sovereignty must be conceded, but on occasion we must pretend that the law is not what that principle suggests. That wholly misconceives the position, in my view. It's surely a matter of balanced interpretation, responsive to all relevant considerations. On one side are the reasons in favour of limiting the scope of judicial review, according the tribunal a real jurisdiction, allowing it to make its own decisions. And on the other side are the reasons for imposing certain boundaries, defining the limits of that jurisdiction. Only an analysis of the nature of the error alleged can tell us how to draw the line on the facts of the case. But questions of obedience or disobedience are neither here nor there. To cast the matter in those terms is really to abandon public law in favour of political knockabout. Great fun for those with an axe to grind, but a sad failure of serious academic critique. For another example, we can go back to Lord Sumption's dissenting judgment in the Supreme Court in Privacy International. In the light of the sweeping ouster clause in the Investigative Powers Act, he held that the court should not intervene to review the tribunal's reading of certain provisions of the Act. But he fully accepted that the ouster clause would not apply if the tribunal exceeded its proper sphere of operation, its subject matter competence, as he called it, or if it acted in bad faith, or infringed the principles of natural justice. It's a judgment that plainly respects the rule of law, whether or not you agree with its conclusions. No one disputes that a statutory provision should be read in the context of the act in which it appears. How could they sensibly do so? So why would anyone want to read an ouster clause as if it were freestanding, unaffected by all the various limits and conditions expressly imposed on the tribunal's powers? I think we might agree then with Lord Carnworth when he says it's ultimately for the courts, not the legislature, to determine the limits set by the rule of law to the power to exclude judicial review. But I'm not sure we need to say, as he also said, the binding effect cannot be given to a clause which purports wholly to exclude the supervisory jurisdiction. We should simply say instead that an ouster clause should be given effect in the manner that the rule of law commends. We don't need to pick a fight when we don't have to. Legal interpretation, I'm arguing, is not a fringe activity operating around the edges of a set of clear self-applying rules. It's a work in every application of a rule to a set of particular facts. Every novel case is a site for argument about which rules are pertinent and what in context they mean or imply. The language cannot offer us a safe refuge from judgment and responsibility. To trumpet the statutory words alone as automatically providing the definitive answer, rather as the dissentants did in Evans, is to abdicate that critical responsibility. When Sir John Laws said in Cart that Parliament cannot dispense with an authoritative judicial source of interpretation of statute, an implicit condition of the exercise of legislative authority, he was not, or at least not merely, making a clever move in the institutional power game. He was identifying a truth about constitutional government. In the absence of judicial interpretation when necessary, the statute lacks a definitive meaning. And the true meaning is not what certain MPs or ministers or officials might have hoped it meant. It's what the statute means in the context of the law taken as a whole, as it applies to the facts in view. The whole law, including the common law and the constitutional rights that are now an intrinsic part of it. That's the nub of the rule of law. It means the governance of law in the sense that every coercive act must be justified, not merely by reference to a specific statute or precedent, but ultimately by reference to an interpretation of statute or precedent that we can defend as part of a unified body of legal principle, treating all alike in the relevant respects. From an instrumental view of law, as chiefly a tool for government purposes, the rule of law may appear to be something else, a limited defence against abuse of the powers conferred by law in Joseph Rouse's conception. But the law has intrinsic value, in my view, as a system of justice, evolving by incremental steps in response to new social and technological developments and fresh moral and intellectual challenge. We may sometimes wish the law were different. It doesn't match anyone's blueprint for the perfect society. But it doesn't follow that the current law is unjust, because justice is an ideal we must pursue in collaboration. That's why we invoke the precedents for guidance. A just decision in any particular case is one that conforms to the law, complies with the rule of law, in the sense that it forms one part of a complex, morally coherent whole. The law may not be what it ought to be from a purely external viewpoint. The view of the disillusioned critic, perhaps, who would like to sweep everything away and start again, preferably, no doubt, with himself or herself as dictator. But the law is what it ought to be if we've interpreted the statutes and precedents correctly, consistently with the basic rights and principles that give the whole structure its moral unity. Historians are divided about whether, in Bonham's case, Coke envisaged the courts repudiating unjust statutes. But the controversy is, in a sense, beside the point. From a common law perspective, as I conceive it, an unjust statute, unjust in the critical sense that it violates basic principles, is simply a contradiction in terms. An unjust statute, so called, can only be a misconstruction, a misreading, attributing dishonourable intentions to its authors. The question is always, how can we read the text so as to treat it as an intelligible contribution to justice or the public good? How best can we incorporate it into the corpus juris? The more the text resists such treatment, despite our best efforts, the smaller its effect on the content of the law. The veto provision in issue in Evans was largely ineffective for precisely that reason. It made no intelligible contribution to the law as a unified structure of rules and principles. That was Cook's concern, I think, in Bonham's case. A statute should make good sense as part of the law taken as a whole, underpinned by the general principles that ensure its conformity to justice. An Act of Parliament is against common right and reason, or repugnant, or impossible to be performed, to give Cook's full elaboration, when it contradicts principles or doctrines on which the law's overall coherence critically depends. Cook was especially concerned with breaches of the settled precepts of fair procedure, which almost inevitably lead to a serious rupture between law and justice. He thought that what purported to be judicial proceedings, but lacked their essential character, could not generate legally valid penalties. That must be especially true of judicial proceedings in which one side labours in the dark about the allegations or the evidence. An unfair trial in which a defendant or detainee is unable effectively to answer his accusers is only a parody. It would not really be an adjudication, and those in charge would not truly constitute a court in the pertinent sense. In AF number 3 in 2010, the House of Lords denied that there could be a fair hearing for the subject of a control order under the Prevention of Terrorism Act, if the case against him were mainly based on closed materials withheld on grounds of national security. The schedule to the Act said that rules of court must provide for the disclosure of material to be disallowed when such disclosure would be contrary to the public interest, very broadly defined. But the House of Lords read in an important proviso. Those rules should be applied, quotes, except where to do so would be incompatible with the right of the controlled person to a fair trial. In other words, the right to a fair trial must not in any circumstances be denied. Admittedly, the court was prompted to do the right thing by the European Court of Human Rights, and Section 3 of the Human Rights Act was at hand to help read down the statute as far as necessary. But if due process is fundamental, central to the rule of law, then the common law must surely give the same answer, as indeed Lord Hope acknowledged, observing that a denunciation on grounds that are not disclosed is the stuff of nightmares. The rule of law in a democratic society, he said, does not tolerate such behaviour. The fundamental principle is that everyone is entitled to the disclosure of sufficient material to enable him to answer effectively the case that is made against him. As Lord Justice Sedley had insisted in the Court of Appeal, you can never know what difference disclosure might have made. And for a judge to hold a hearing in which the party affected has had no opportunity to respond is, he says, constitutionally subversive because it negates the judicial function critical to the control order regime. Law, in other words, collapses into arbitrariness and tyranny. It's interesting, I think, that Lord Hope expressed disagreement with Sedley's reading of earlier House of Lords judgments, in which it was held that there could sometimes be a fair trial, even when little or nothing has been disclosed to the complainant. In other words, even though Sedley was right about the law, he should have pretended the law was what his superiors had claimed, something different. Isn't that rather like saying that a surgeon should have followed hospital protocol and killed the patient, even though he could see that such a course was very dangerous in all the circumstances? I think Sedley was exercising the moral responsibility intrinsic to legal judgment. He refused to collude in an injustice of the kind that would impugn the legitimacy of the whole statutory scheme. His statement of principle is quite uncompromising. He says there's nothing in the nature of a control order with its potentially devastating effect on the life of the individual affected and his family, which calls for less than the maximum judicial oversight before it's confirmed. Sedley properly aligns the law with the rule of law, the universally valid conditions for the legitimate detention of anyone on mere suspicion without an ordinary criminal trial. Does this style of interpretation amount to judicial disobedience or improper judicial activism? Only if you think that the law consists in statutory commands that can operate in a moral or constitutional vacuum. If instead you think that the law must always satisfy the demands of the rule of law to retain its quality as law, then such derogatory characterizations are very wide of the mark. There's simply nothing to disobey, in my view, before the correct construction has been determined. And that's not something achievable in ignorance or disregard of the relevant legal principles. Sedley joins the pantheon of notable dissentients fighting for the integrity of the rule of law. Think of Lord Shaw in Crown against Halliday, ex parte Zadig in 1917, repudiating the majority's view that Zadig had been lawfully detained without trial under sweeping defence regulations, very doubtfully authorised by the Defence of the Realm Act 1914. Such arbitrary executive detention was, he said, poison to the Commonwealth. And Lord Atkin in Liversidge and Anderson in 1942, disputing the majority's reading of Regulation 18b, allowing a minister to detain anyone whom he had reasonable cause to believe to be of hostile origin or associations. The court's refusal to treat reasonable cause as a judicially reviewable limit was, said Atkin, more executive-minded than the executive. At one level, these famous dissents invoke legal tradition, familiar common law standards. But at another level, they appealed beyond tradition to a more abstract ideal of the rule of law, the conditions of legitimate government, defining the boundary between law on one side and arbitrary coercion on the other. You can hear it in Lord Hoffman's language in the Belmarsh case, a more recent case about detention without trial, when he denied that the threat of terrorism constituted an emergency amounting to a threat to the nation within the terms of Article 15 of the European Convention. He asks whether the United Kingdom should be a country in which a person who has fallen under suspicion could be seized and indefinitely detained. There is then no very clear division, I think, between English or UK law and the general principles of right that determine whether state coercion is legitimate, whether there's any genuine obligation to obey what purports to be binding law. There's no question here of disobedience to wicked law, these dissentients deny that the law was what the majority claimed it was. The law must be interpreted correctly, consistently with basic rights, because otherwise there is no true law to be enforced, only arbitrary official demands. The law cannot coherently flout the ideal of the rule of law, which forbids the denial of fundamental rights. What then do we say about the long debate over judicial review of statutes by constitutional courts? It's an institution famously defended by Roald Dworkin and strongly challenged, perhaps equally famously, by Jeremy Waldron. Is such constitutional review an integral feature of the rule of law, or instead an affront to democratic self-government? It follows from my argument, I think, that the debate is, to a large degree, misconceived. If, as Dworkin recognised, legal interpretation is a moral enterprise, if the law's requirements depend on moral evaluation, no statute can properly be read as infringing constitutional rights or flouting the rule of law. There may well be misconstructions to condemn and rights to clarify and affirm, but there's nothing genuine to strike down or declare invalid. The statute applies only to cases in which its application is consistent with legality, with the rights that give concrete expression to our basic values of human dignity and equal freedom. In his article, The Core of the Case Against Judicial Review, Waldron specifies the assumptions under which his argument against judicial review of legislation chiefly holds. There must be a representative legislature, universal suffrage, an independent judiciary authorised to review executive action, and a strong commitment by most members of society to the idea of individual minority rights, even if there's substantial disagreement about what precisely these rights protect. If there's a Bill of Rights, it won't settle the issues at stake in the disagreement. What it requires will inevitably remain a matter of dispute among reasonable people. Waldron is seeking to characterize here the liberal democracies that provide the main context for the debate. Waldron argues that under these assumptions, judicial review of statute is illegitimate. The people should settle questions about rights through the ordinary legislative process. But these are precisely the conditions in which the distinction between judicial review and judicial interpretation is most elusive, indeed illusory. Judicial interpretation, duly sensitive to rights, does all the necessary work, bolstered by wider public recognition of these rights and informed by the continuing dialogue about their content in different circumstances. Waldron emphasizes a distinction between strong review of the American or Canadian kind and so-called weak review of the UK or New Zealand kind. He objects only to the strong variety. But his focus on declarations of incompatibility under the Human Rights Act, Section 4, shows that he has little appreciation of the interpretative power affirmed or strengthened by Section 3. If he acknowledged the importance of that interpretative power and accompanying responsibility, his position would look much more ambiguous. Presumably, he would disapprove of Section 3, preferring judges to stick to the plain words of the statute, treated largely in isolation from the rights culture he otherwise approves. But would such a pedantic legalism be consistent with the rule of law? And could such a rigid textualism or literalism be reconciled with Waldron's own account of the nature of law and its inherent connection with human dignity, as defended in his own Sir David Williams lecture on how law protects dignity? It's an account of law that emphasizes its procedural and deliberative qualities, which honour the rational agency of the law subject, who's entitled to argue about the correct application of the law to her own individual case. You can find the lecture published in the 2012 volume of the CLJ. That moral concept of law and its animating ideal, the rule of law, is, I think, an integral feature of liberal democracy, at least in its British version. It means that instead of asking the usual question, whether Parliament's instructions should be followed or evaded or simply repudiated, we should ask a different question. What does a statutory provision actually mean in the context not only of the rest of the Act, but of other relevant statutes and common law doctrine? And crucially, what it means is always in part a function of what it could mean, what it could legitimately mean in a legal order that we treat as a source of genuine rights and obligations. That, I think, was Cook's view, or at least the best way to understand him.